I'd love to look at that.
We are back to Senate Judiciary. Going back into S12. We have Judge Zone on the Zoom, I believe. There it is. Thank you, Judge, and sorry again for having you for the short notice invitation. I wanted to make sure we at least cross off all the stakeholders at the very beginning of this bill. But either way, yes, we're going over the House changes to S12 and wanted to hear if you have any input. I think there might be a few questions probably related to the initial procedure regarding approving access to records, but we can get there when we get there.
So, Tom Zone, Chief Superior Judge, I have reviewed the version that was passed yesterday. Understand it in terms of the changes and what I believe the intent is. I do understand that there may be some questions about applicability, how we apply this when there's going to be access, which I think would be basically the exceptions on page 25, line 8. Is that what I understand, Mr. Chair, that you were saying there might be some questions about?
Yes.
Would it be helpful if I explained how I foresee this going forward?
That would be good.
All right. So the statute, as amended, provides that prior to the use in a court proceeding, the party wishing to use it has to provide notice before they can do it in open court. The court thereafter has to determine whether the record may be used prior to its disclosure. As I understand it, the intent behind this is that someone doesn't stand up in open court and say, "I have this sealed document about this witness, Judge, and boy, it's really good information." That gets the information out before it should. So the intent here is that prior to the hearing, the party has an opportunity to file something under seal, and it shall remain under seal if they intend to use that document at the time of the hearing or trial. The court then has an opportunity to assess whether or not it's going to be able to be admitted. A question comes up as to what is the level of information that the court has to find for this admission. The document, the court would have to determine, well, is it relevant? The court would consider whether or not the information is admissible. But admissibility is not the test necessarily for whether this sealed record could be used, because there's often times where information and records are used that they're not under the rules of evidence, they're not admitted. For instance, if you're cross-examining someone and you're using certain records, those records don't have to be admitted generally. If you are using the information to refresh someone's recollection under the rules of evidence, you're using it, but the information, the sealed record, for instance, would not be admitted under those circumstances. And the court also, under the rules of evidence, has the ability to determine whether the probative value of the information is substantially outweighed by the danger of unfair prejudice and other rules. And that's what we call Vermont Rule of Evidence 403, the probative prejudice balancing test. And so the court has the opportunity before the trial, if something is filed, to be able to assess whether it can be used. At a trial, if something comes up, there are often times where the parties may not know about the information ahead of the trial or may not realize the relevance of something prior to trial. And if that occurs, they might not have filed a motion or a request to have something be used that's sealed. What would happen, as I envision it, is that it's like issues now that we have at a trial. If the court has something that is generally not admissible and a party thinks that the door has been opened or it's suddenly relevant, that party can say, "Your Honor, can we approach?" They can then approach. They can discuss it with the court, say, "Here's what the information is. Here's what I want to use it for." And the court has the opportunity to assess it at that time. That would be outside the presence of the jury. If the court determines that the information is something that can be introduced, then generally that bench conference would be something that is a public record. if the court just says, well, no, it's not coming in. The court also has the authority to say, well, we're going to seal that bench conference because it talked about something that is confidential. It's not public. And so that provides the court with flexibility to address the situations on a case-by-case basis. And we currently do that now with a number of areas of evidence. So it's not a new procedure for the courts and the attorneys, for that matter, to understand how we would go forward.
Thank you. So is it then just correct to say generally that what was passed by the Senate, the mechanism for requesting access to sealed records, that is a mechanism that the court can use, or are there any issues?
Which section are you referring to?
Referring to the as passed by the Senate version, and essentially on page at the bottom of page 24 going into 25. And then also page 25 and going on to 26 for criminal justice agencies, the HBO, attorneys, and law enforcement.
The section you referenced going from 24 to 25 is, I would suggest, is basically right on par with what has come out of the House, but the House's version is more particular as to the process, and it provides for the sealing of the materials ahead of time, and it provides a little bit more, I'll say, guidance on how to utilize it. So I don't think that they're markedly different, because I think what a court could do is, by local rule or by the rules of criminal procedure, impose the restrictions that the House has put on as far as filing things ahead of time and what would happen. I think a judge has the authority to do that under the applicable rules anyway. So putting it in statute just makes it clear that this is going to be the way it's done in all cases. That's not to say that what was passed by the Senate we would not be able to make work. It just is a little bit different.
Any questions, comments? Actually, one last question. Do you see any issue between differentiating between the words access versus use?
That's been something that's come up in the past. I think that the House version, if I'm not mistaken, on page 26, lines 7 and 8, says a defendant may use a sealed criminal history. And I think that until that was put in, I think that was, if you will, more of an issue, because they are different words. And we have had that word access for records for a while. And this is something that does come up occasionally, and the clarity is helpful. So it puts it on par. Subsection 2 on page 26 of the version 4.1 as passed by the House, that makes it clear that the criminal justice agency can use it. And subsection 3 on line 7 makes it, on page 26, makes it clear that the defendant can use it. And so I do think that where you look at words in statutes, if they're used as the rules of statutory construction talk about advisedly, that there can be viewed a difference between those two words. And the clarity of having the word use for both makes it clear that they can be used. And so I guess that's a long way of saying they're different words. They seem to mean different things. And the way this bill is structured, it puts the defense and the state on equal par with to be able to not only access, but use.
Thank you.
Hi, Chair. I hope it's appropriate. I don't want to overstep. I'm wondering if
You just identify.
yeah, sorry, Karen Dolan from House Judiciary. one of the pieces that came up for us in testimony was around capacity shifts in judiciary of having requests for access also come to the court in addition to use. And so I don't know if that would be helpful, but we found that helpful in our judiciary.
I don't know that. I don't think that we're contemplating having two different types of hearings. One hearing to access a record and then another hearing to use the record. Unless I'm misunderstanding something, I think there's just a uncertainty around where to use the word access, what it means, where to use the word use, and what it means. That's my.
If I could, I would suggest that if you're looking at that issue, the way I look at it is, if you're going to give someone access, what's the reason you're giving them access to it, and what are the reasonable uses of it? So if the idea is that you want someone just to be able to access it and look at it with no use, that's a policy decision. But if the idea is, well, we want them to be able to get it because it may prove useful, whether it's for the prosecution or defense in a case, then certainly you should consider, as appears to have been done here, making it very clear that not only can you look at it, but you can use it.
Thanks.
And as I understood our bill, you asked once of the judge for access after we allowed you to use.
That's how I understood it, but I guess
There's show behind this.
So I would just say my interpretation of what you had in the Senate proposal was for the initial court appearance was looking for access to the record. But then you still have the same language that is also appears in the House proposal at the beginning of subsection C that talks about if you're going to use it in court in a court proceeding. So it's a different, so if you want to access the record, right, for certain purposes, then you're asking the court for permission to do that first step. But then if you're going to use it in court proceeding, then it would be up to the judge, like, and you have that same language in both versions.
Whether it's in this.
Whether it's in this. But you do have to notify the court.
Judge Zone, isn't it already up to a judge to determine whether or not something is admissible in court if that question is asked?
Yes,
Like anything in general, that's already a process.
correct.
Okay. I love it when my complete lack of law degree, I'm correct in how the system works.
any other questions? Judge? Thanks again, Judge. Appreciate it.
My pleasure.
Short
Have a
notice.
great day. Take care.
So we've got 15 minutes to fill that's 8 and 7. So much. How will we feel about this deal?
It's a familiar feeling.
Jake, you want to sense of deja vu?
Yeah, I mean, I liked the Senate version that we sent out because I felt like it hit that issue. If it wasn't otherwise, you know, my favorite bill, then I felt like that square the circle. And I thought the other body could accept that. So I appreciate their work on what they've said back, but it is and continues to be a deal breaker for me. That we're supposed to be sealing, but everybody can have access. When I say everybody, I mean people listed here, law enforcement agencies, there's the attorney general himself can have access. Then they have to ask the permission in order to choosing one reference. So that's I can't vote for it in the same way that I couldn't vote for it last 4 or 5 years.
I share Senator Burns' space. The one thing I do, as I said, actually really like from the House version is that addition of the notifying people that they can stay. You know, as this bill came out of the Senate, one of the big hesitations I had was that we were putting the onus on people who don't have a law degree, don't know what we're doing in this building, to know that they can say that, and that would be. So I actually do really appreciate, and if we were to try and figure out the path forward, I would want us to keep that addition from the House. The rest of it, I don't.
Yes. I thought the bill that came out of the Senate was a good bill. After hearing more testimony on this. If memory serves me correct, I supported judicial review prior to a law enforcement officer. In receiving that, I also supported the IMAG's request for deferred sentences as far as, but in listening to the testimony, I think it's very unique that the House approaching from a different perspective from access versus use. And my first concern as someone experienced in this is officer safety. I think having access to something without necessarily using it, without, once again, court review, I think is a novel approach, and I can support that. But I think both for the veteran officers and the new officers coming in. So if we have a case that has been sealed, and there's this thing that there's codes or whatever that are put into your base, whether it's 10 or caution or whatever else. So if that code is tied to this one incident dealing with this individual, is that part of the case? Is that not allowed to be in there for officer safety reasons? So I think we sent a very good bill to the House, and what I said, I think 11 cents of eyes did some improvement to the bill, and I'm going to concur with what they sent us, because I don't feel that this is a threat to access versus use, which still has to go through a judicial review for a judge. So that's my feeling on it. I don't support the House version of this.
What do you mean by the judicial review piece?
In reviewing their bill, it appears as though their bill S12 is officers can have access to the information, but they can't necessarily use it in a case. They still have to, correct me if I'm wrong, Representative Bill, they would still have to apply to the court to request to use the information that they had access to for officer safety reasons, as an example.
Of the yields of ledge council, that's my understanding.
So, we'll take you to look at the language. So if you look at on page 26 of the House proposal of amendment in subdivision 2, criminal in the current law, criminal justice agencies may use the criminal history record, right? So they can pull it up, they can look at it. You go back to your definition for criminal justice purposes, which is at the beginning of the bill. So means the investigation, apprehension, detention, adjudication, or correction of persons suspected, charged, or convicted of criminal offenses. Also includes criminal identification activities, collection, storage, and dissemination of criminal history records, and screening for criminal justice deployment. So you can use it for those reasons. You do still then have the layer of the intro language for subsection C, which is then you're going to use that, but if you're going to use it in a public proceeding, therefore meaning that it's not just you as the officer or other people who have access via being part of the criminal justice agency, and you're going to put it out there to people who would not otherwise be entitled to see that, then that's when you have to notify the court and they're going to pay that.
Thank you.
Sorry,
Yes.
just in terms of officer safety. So if we had gotten the bill 5 years ago, by your logic, that officers would have been safe for the last 5 years. That every year the bill dies, and we don't have officer safety. I think the Senate version of what was sent out would introduce more officers in your terms. Not as much maybe as the House, but the status quo, as I've said, is the worst case scenario for all of our reasons. And yet we keep crashing these bills because of the idea of asking the judge whether you can access this directly. So if we don't get a bill again this year, it seems like public safety, officer safety, all of these concerns are exacerbated. Which to me is an argument to compromise, but I feel like we never get the compromise that this committee has always sought to move away from this budget. So that's my hang up there is in the name of making the safety safer, we continue to not find it. And then the judicial review find is what it's not an expansion of the offenses that are qualified, though I think that's good. It's making sure that people who would have had expungements have some protection from all law enforcement and continue to share their victims.
And I appreciate your opinion.
Yeah.
Officer safety, in my mind, is first and foremost, because without officer safety, you don't have public safety. You have no one to respond. I'm going to use a term which I know you are not necessarily fond of, bring your attention to it. It's just another tool in tool.
Yeah.
In reference to, this is not going to prevent officers from, they may help. But my concern is every little bit of piece that we can get to help officer safety. Is going to be
Right. I think I'm just saying if you don't get a bill, that doesn't get us any more officers.
all depends as to which lenses you're looking through, as to what you consider a good bill and not such a good bill. And I say that we sent them a good bill. I think they made some improvements on the bills. That's why we should just support their bills.
I think it's also important to remember that what we sent them, maybe we had the conversation, I think extensively about officer safety before we sent them the bill, and we included the provision for the exigent circumstances, which was meant to address that issue. So, you know, if you're responding to a domestic and you want to know if that person has, you know, a prior offense that involves firearms, but it's somehow sealed, or a prior history of violence that's sealed, you can get that information under the exigent circumstances exception, even in the Senate version.
That's supposed to delay, and you can ask or request it if you sure review. Yeah, we're not, what I find that is. And then you still have to, I see what you're saying, you still have to show after the fact that your question was. Yeah.
You don't have to show it wrong. So it's page 26, line 4. Yep. So page 26, line 4, access the exigent circumstances. You define exigent circumstances for the holds. Existing case law.
It was probably wondering if this is what person does. I'm wondering if so there is a piece in here at the very end of line 10 that if someone believes that the officer violated the second, they can make a complaint to the criminal justice council, and then you would have to prove that there were exigent circumstances, but there's no, only if someone reports it.
And I agree, we made that exception, and it's a good exception. I think that have taken one step further. In the Senate bill, you had to show exit circumstances. In their proposal under having access, it just opens up to prevent the unknown.
And I think if your primary concern, only concern, let's say primary, is the safety of law enforcement, you would get rid of all expungement across the board because you want most records, most information in itself. But we've always been trying to balance the interests of those who would prefer total information with those who prefer no information. That is full expungement. It's there now for qualified offenses. So, it's trying to hit middle ground. I thought the Senate bill did a great job with the exigent circumstances piece and the judicial review piece, such as it was, added more qualifiable offenses. And it seemed to me that it was protecting everybody's interests. We went to keeping the deferreds with the general's office. It was great package in my opinion. Not that the House didn't add some things that I like, not the committee likes, but the linchpin of it was pulled out. And I feel like it just took us back to square one, which is why we're having this discussion.
One last point that, okay, I think, quickly in terms of officers taking it, I think police officers kind of respond with the same level of having their head on a swivel, regardless of whether they know that somebody has a sealed record of a disorderly conduct from 10 years ago or a simple assault from 8 years ago. If you're responding to an act of domestic assault, you're not going to, in my opinion, be more relaxed in your approach if there's no record, as opposed to if you find out 10 years prior they had a DUI or another disorder, either domestic assault, quite the time. But
And I realize that's a law enforcement term, that almost swivel, okay, but advance notice sometimes has kind of.
How many, this may be a question for Michelle, but just trying to refresh my memory about how many sealable offenses are considered under this bill or by nature.
Well, as you know, we don't really have a one set clear term for that. Listed crimes are not eligible. I can't think of any violent felonies, something like that. Something like simple assault, is eligible. So I haven't done like an analysis, but I think, this list has evolved over a number of years with, maybe initial recommendations coming from the sentencing commission, and then it's gone through both bodies and they've kind of finessed it. So, I think you kind of tried to respond anytime somebody brought up something and said, oh, this should be on there as a violent, so I don't know exactly, but I can say in generally, no sex crimes are eligible. No violent felonies. There are some involving assault that are misdemeanors and fine,
Yeah, because there's just my recollection that the vast majority of the list of stuff has no violence element.
Right.
So this sort of conversation of like, we need to know, because there might be some they're not seeing it.
Well, that's what I mean. There's 12 violent offenses. There's a statutory period that hasn't run where they haven't offended again. So it's not, and again, if you're looking for most information for law enforcement, if they want any, want any bar to access for anything or any, but it has to be balanced with other goods that the legislature has identified, which is trying to free people from their past records in carefully controlled cases so that they're not subject to people prejudging them based on tenure entanglement with the law.
In closing, I guess we can debate this
Yeah.
the next coming week here, but I think the House has approved on the bill.
we can move on from the different process. So take on one, but the first sentence piece, another big component that's changed. Thoughts you have on that?
Back to our version.
Yeah, I'm wondering if Marshall, do you have anything to add about the first?
I think that the first sentences have resulted in the expungement of Vermont since 1971.
when we first introduced deferred sentences. I haven't actually, it was sort of surprising to me that deferred sentences became an issue in this bill because I have not over the years heard complaints about deferred sentences being and the expungement of records after a deferred sentence being problematic. Because as I mentioned before, for any serious offenses, the only way to get a deferred sentence is with the agreement of the prosecutor in the first place. So it, it hadn't been a controversial topic. So I was surprised to see it come up in the first place. From our perspective, it would really damage the use of deferred sentences. When we as defense attorneys explain a deferred sentence to our clients, as Attorney Mann has said, it is a very high risk, high reward situation. And so there's a lot of clients of ours that we advise a deferred sentence is not in your best interest. This is too much risk versus, and you're not a good candidate for risk. And so, it's always been something that applies in those unique cases where both the defense and the prosecution really agree that it is the right outcome. And that's where the vast majority of them get used. And the ones that happen unilaterally because only one side wanted it, the defense wanted it, that's narrowed to only a few types of offenses, no listed offenses at all. So from my perspective, it's just something that's been working for a long time, for longer than I've been alive. And I could not see any good reason to change the system that we currently have in place. And I do think that if we change the system, it will result in less deferred sentences, and more cases going to a contested resolution, which in the case of a deferred sentence is clearly what nobody wants. Because whenever you do a deferred sentence, that's because the prosecution has a case that they think, there's some reason why we want this to go deferred and why we don't want to take this to a contested public resolution. The defense has some concerns too and says we don't want to take this to a contested public resolution. And so they agree on a deferred sentence agreement. And frankly, I think that there'd be more contested cases and less agreements. And I don't know whether that would be good or bad because it's hard to say, whenever there's an agreed upon case, it's hard to say whether anybody won or lost or whether anybody should have won or lost or whether there was an injustice. So I can't tell you whether less deferred sentences is a good thing or a bad thing, but I think that getting rid of expungement for deferred sentences would make it less attractive to defendants and it would certainly be less defendants willing to take them.
I'm assuming, and I'm hoping you'll correct me, Marshall, if I'm wrong, that contested public proceeding would take a lot more time and resources than an agreed upon deferred sentence, and thus would have both a fiscal impact and an impact to the backlog, which we know is one of the primary drivers of some of our public safety challenges. Would you agree?
That's certainly true. I would say at this point, there was a point where the courts were pretty backed up badly. At this point, there's a lot of courts where cases are moving, but the cases that are still getting hung up are those cases that have to go to trial. Like that's what we are, struggling with is getting trial dates. We're moving cases a lot better than we were a couple of years ago in terms of getting cases that are going to be resolved to the point of a change of plea and getting them out of the court system, closing them out. But we're doing a lot of trials, but there's still a huge backlog of trials waiting. So yes, definitely, cases that go that contested route are the ones that are jamming up the system right now, causing the backlogs that we have and the management that we have to do of the trial calendar and, what cases get tried every month and what cases don't.
So just from a pure backlog and resource standpoint, less diverse sentences would be a bad thing.
The more that we can come to agreed upon resolutions in these cases, especially these long-standing backlog cases that have been sitting for a long time, the better. Those are tough cases to resolve. It's like the longer they sit, the harder they're getting to resolve. And that's proven to be a real difficulty. We have a real docket of cases that are thorny and are only going to be resolved by trial, and they've been waiting a long time to get to trial, and we're still waiting.
We want to switch gears to S87. We don't have any witnesses, but any closing thoughts on as well. We're gonna be revisiting it, obviously.
And just the last thing I'll say, to be clear, I would support dropping the bill, but having a further proposal then for a conference.
Yeah, but it's very likely going to be a conflict. So. Soon,
I'll work on getting it passed out of the house, sir.
Great.
Okay. Well,
Discussion. So S 87 extradition bill. So. What if we leave off on this?
We did have a discussion of the numbers of the days. Then that breaks out 30, 60.
Yeah.
Becomes 90, 30. And so we were discussing that. As that was the only thing that's part of this.
And then. Main part was. Ironically, is they at the House added the judicial review piece. Which we didn't have. And so. That was on page 3. Starting on line 5. This
I would be willing just to confirm what that kind of proposal.
Yeah. That's what I'm leaning towards as well. I think one of the things that we heard yesterday regarding the other states that have the 30 days, rather than getting extensions, the person just gets released after 30 days, then immediately rearrested, and the 30-day counter starts over. Same thing, but either way, I think that what we have in case law here regarding the 90 days being a reasonable time to keep some of these things, and with the additional layer of judicial review, I'm kind of the bill as they sent it to this.
But we don't just have 90 days because there's still a 30-day extension, so it's up to 120.
Yes, I think the uniform code, get a chance to look at the uniform code.
Shelter, I see that everybody else was at 90 until it's.
Oh,
I thought the uniform code said 120 days was okay. We're gonna confirm.
it's 90.
Why does nobody follow it? And that's completely not.
If no one follows it, you're right, it is not very uniform. I mean, I think the House made it better by the addition of the judicial review. I just don't think that's still regret, so fine.
And I'm gonna leave that up, but I also just want to remind you that there's a difference between some of the states with different numbers. So
Yeah. The people available after the 90 days.
Yeah.
Yeah. Which is something that's not accessible. I mean, people in our state are essentially as a matter of course being extended beyond the 30 days. It's not going to be paperwork back to the other states. So it's generally going beyond 30 days in most cases. I don't know if it's landing somewhere between 30 and 60 or 30 and 90, depending on how vital that is.
Are we the only state, Michelle, where people are available? Because we will be the only state that has something other than 30 on the front end.
I don't.
Or something
that's-
above 30.
I didn't, I mean, I didn't do many, like, so, extradition, so a uniform extradition has to be held within 30 days of the arrest. State requesting extradition has a time frame to pick up the person just to 30 to 90 days from the arrest.
I think it's right to say we're the only state that's getting above 30 days. It's just that there are many states that do have 30 days. So presumably there are other states that have more than 30 days.
You're right, I can go back and listen to it again.
Kim, by any chance, do you know what other states have? Or just
Testimony yesterday, Rebecca, sort of quickly looking at the number of days, start with 30, but then have the extension, and another start with a larger number up front, but we didn't have, it wasn't a complete breakdown. I think the tricky part about the Uniform Extradition Act is that it's not as uniform across the states as you would think. That's the tricky part there.
After passage is showing the semi.
yeah. Reform on occasion considered.
Red one. Something red one. Oh, something. Finance. They gotta get something done, right? We got that, that's right. But
What I hate is
there will be some pretty logical and solid. So two things.
So forward funding the launch, we're gonna elect the core company.
it's so
launch it was that point.
I'm not stressed.
What was it? Yeah, but it was on Netflix.
Yes, the president, he's also sure. Just like.
Extradition.
Anyway, that's continuing with such a.
That used to the service. We can cut some just.
I
pick them up like
don't know.
an hour and a half.
Christina said.
2 hours. So, yeah, like. It might have to. And all of the reports that is something like, we just get to everyone from Massachusetts. Thank you for coming.
You,
I think we got beds and expensive.
I know.
Listen, it is, the good side close, it's like close to $30 per year. I have no idea what that program is.
Asking Westlaw, like, if they can like do a thing, because Kim is very right, which is like, a lot of times when you take a, and also because this, the difference is like on the 30s, right?
Yeah.
People, if you do, you kind of tweak it, you make it fit yours. It's uniform to an extent, but not like a compact where the language has to be exact from state to state to state. So.
No,
If that's.
Just now.
Or UCC can pass the bill.
So-
What's the UC say?
It's a good start. I don't know. You can change it. Just ask him. No. Yeah.
We don't.
We did like.
Whoever's reporting it, bring it up, says, hey, this is great. Don't
Show me a list of cases.
Can't change it, whatever.
Yeah.
Right, like,
Yeah.
it's my first round, kind of just-
Couple on bill. Yeah.
Massachusetts, I got programs.
It's only one.
Okay.
Yeah.
And I think it'll be fine.
Oh,
Yeah,
okay.
that's my class.
I'm here all week.
School, they've got.
Sorry. Oh, no.
And that's where those kids should be.
Where's Josh?
There's a job I ever actually managed to do it.
So, go on.
That's good YouTube, right there.
Yeah, especially because of the cost, not even for law. The compacts are crazy. Like, I don't understand this when I start. Because they are like It's more between.
Anytime
No,
puts
this
the
is
readers off, they're out the deck. Oh, okay. You run it?
That.
Where? Yeah.
You know,
That's up.
so.
They corporate cup?
It is.
Yeah.
Then you're up on one, and you can.
So even if you're.
See that button?
Even if I had,
You
know,
Yeah, but
normal,
you know,
But without
It's
the.
because they're actually just.
Then you get more.
We're still a long ways away from.
So initial
And so
period
the state of Vermont
That
actually
means 30
utilize a
days.
contract administrator whenever we don't have them on the rule.
period is intended to allow time for the arrest to take use under government warranty.
Are you saying that the general's office to try report in 2014?
Use is not arrested.
You know, it was CRG that did the report. And I believe it was the Sentencing Commission, that made them do the report, but they did it on some sort of a. Was it some way or another grant funded? And it was done through the Sentencing Commission, and it was,
You know.
something about uniform crime classification.
I did see that one.
And it resulted in a spreadsheet that had every crime in Vermont.
Yeah.
Sorted by how many times it had been charged in the last, I forgot how long it had but many years.
Okay.
Is this the report regarding Act 98? Oh, no, that's a different one. Hold on.
I can email it to you, because
That'd be great.
in order to find it, I had to email CRG. And
Okay.
they did send it to me, so I can.
That would be fantastic. I'm very curious. I like searching the reports, legislative reports page and not having much luck.
I already tried to find it there.
So what is the rest of the committee's opinion on this? What do people want?
I'm fine with concurring, you know, when you're looking at the days. In section 1, it's not to exceed, or not exceeding that. The judge can look at that and be like, to the law, they have up to 9 days, and then the extension of 30 days has to be granted by said judge. And then also with the part, jumping ahead to section 3, about what the House added. Senator Norris talked about yesterday, about having that judicial review for you. Extra days, everybody, I like that too. So I'm okay with, concurring, just hearing about, you know, case backlogs, having to have a hearing after 30 days, just to extend. So we're doing that already. I'm okay with Bill, that's that house.
The fact that people are available after 90 days gives me more comfort rather than just releasing somebody and rearresting them and putting them back in. We start the calendar.
I don't feel like I have, I'd like I said, if you put the House read it better, but this number, especially, I don't feel like I have enough information. Like I have a really significant concern about making us a major outlier in a place that has someone's liberty interests at stake. So like, I just don't feel, and I just sent Rebecca an email to try to get a little bit more information about what other states do in terms of, are there numbers between 30 and 90 or numbers that are 90 or over 90? But what I did hear from her yesterday is this does make us a pretty major outlier. And so I just want to know, are they available in other states? Like, are we a major outlier? Like, I would need some compelling reason to make us a major outlier in terms of someone's liberty interests. And I don't presently have the information.
The thing that, get what you're saying, on the information, I think the thing that makes us a major outlier in a positive way is that people are available after 90 days. Whereas in other states, people are just rearrested after the 30 days and the timer starts again.
No, I understand that, but I guess the piece that I would want to know is that true in any other state? And what do their numbers look like? Because, you know, we're sort of using that as the justification for making us a major outlier in the numbers. But that may be true in other states that also sit with 30 days or so. So that's sort of the piece where I just don't feel like I have the information. Like, we're making that justification to make us a major outlier in other places. I don't know if we are the only state that people are available in. I understand that is true here, but it may be true in a bunch of other states.
Senator Brute, did you share your thoughts on the bill?
Well, as I did the other day, the only piece of it that gives me pause is going from 30 to 90 days up front. So that's up to, so granted, it might not be, but could be 3 months where somebody's in prison and nothing's happened. No one's paying attention to them until we get 3 months in. As it's now, something has to happen actually. So, I mean, if you went to 60 days there and you have 30-day extension, you're still at 90 days. But it seemed to me one of the triggers for this was that governors were not, commanding states were not acting within a 30-day period. And so 60 days seems like doubling the time could take care of that without producing additional.
So maybe we can hear a little bit more tomorrow then. Michelle offered to get a bit more information about some of the states here.
I think we lowered
We did lower, I would not mention that the 90 days was our decision that we sent over and we voted that out 5-0.
90 days upfront.
We chose
The
the
time
90 days.
periods are exactly the same in the two versions. You guys, there's no changes, there's no differences between what the Senate passed and the House passed with regard to the timelines.
We sent them that.
Yeah, so they agreed with this.
I just had more information that given me more concern about it, and we didn't lower it from current law. What the proposal was to raise it from what it is now, which is 30 days to 20. And we said, no, that's too much.
Right.
But this bill is raising what is current law.
Yeah.
It is triple what is current law. And I felt comfortable with that until I've now heard more testimony that makes me uncomfortable.
Rebecca, we were just about to wrap up, but I can see you're here now.
Okay,
Did you-
so maybe that's good timing or not,
No, it's good.
or
And,
too late.
But we were gonna visit it again tomorrow.
Yes.
Just sleep on it for a day, and I can show us some provide this information, but if you had any thoughts you want us to share. Bill? I know you talked about it yesterday. So.
Yes, I did, and for the record, Rebecca Turner from the Attorney General's office. I think if I heard just a little bit though, there were questions as to, again, what numbers other states had and what the uniform code had an example in terms of this. Now, what I shared yesterday was that I could not find any other state having upfront, so there's sort of 2 points. The initial grant of time that a judge can hold someone without bail or order bail, and then the state can go and ask for an extension, an additional amount of time, right? So our law total is 90, 30 days right now, 60 days extension allowed. It's a total of 90. What I shared yesterday was that I found that no other state allows for a 90 days upfront and a 30-day extension, right? I could only find a federal law that allows just 90 days upfront, no exceptions. That most of the states I found just did 30 days upfront, and some also did an extension allowable of 60 days, so totally 90 days. So mirroring Vermont. And what I can do, I didn't have a chance to confirm the uniform extradition code because it seems to me that it's mapping something. I think the 30 and then 60 is what the uniform code was, but I wanted to confirm that. So that's just what I wanted to share.
I mean, that.
I did. So I appreciate that. So that would make Vermont a major outlet. No other state has 90 days upfront. Is there any state that you found, Rebecca, that has somewhere between 30 and 90, that has more than 30 but less than 90?
There is, and I think I have to double check this. I'll have to double check that if I could. I'm not sure.
That's fair. It's.
And I know you were
on the
talking,
spot.
and I know you were talking specifically about the 60 days yesterday. So I just wanted to check. Thank you.
Thank you. Committee, anything else? Will we adjourn? Thank you. We can.